Welcome everybody to another episode of Reach, where the Autism Society of Florida tries to reach out to those communities across our state and beyond in bringing you hopefully valuable information. We are here to give you what it is that you need. So if you find something in your life that you need a little bit more information about, just message us, let us know, because we will do what we need to do to find those really fabulous specialists out there who can bring you some really great and valuable information to hopefully make your lives a little bit easier and a whole lot better. So thank you for joining us today. Today, we're going to be talking about a topic that really, I think every parent of a child, whether it's a young child or an adult person with autism is concerned about and has to really keep in their minds. Even if you have a child who you think is really on a great trajectory to be, independent as adult, it's still good to be thinking about some of these things when they're children, because this is one of those topics that you need to start thinking about. You need to start talking to family members about your child, because although parents don't like to think about this, chances are very good that your children are going to outlive you. And as a parent of a child with autism, sometimes we really need to very carefully orchestrate, if you will, what's going to happen when we go, and plan a little bit better with a little bit more detail than any parent, because anybody who's a parent, we're all concerned about leaving our children behind. And but for this particular community, it's of course an even greater concern. So I want to thank you guys for joining us. We're going to be talking about guardianship today. So we have a couple ladies with us from the NSU, Nova Southeastern University, Adults with Intellectual and Developmental Disabilities Law Clinic. So welcome, ladies, and I'm going to give a brief little bio on you ladies. So the first one we have is Talhia Rangel, and Talhia is one of the clinics over at Nova, one of their staff attorneys. She graduated from the NSU Shepherd Broad Law College of Law in 2019 and practiced family and marital law before beginning her work at the clinic. So Talhia, welcome this morning.
Thank you. Thank you, Stacy, for having me today.
And then we have Leigh Markowitz. Leigh is also a staff attorney at the clinic. She graduated from Duke University School of Law in 2019 and then spent a year clerking for the Florida's 4th District Court of Appeal before joining the clinic team. So Leigh, thank you so much for joining us.
Yeah, thank you. Happy to be here.
Okay, so we're going to kind of roll into just, there's a lot of parents, I'm sure, that are listening to this, and siblings and grandmas and grandpas, and maybe even some teachers and other professionals that really, when they hear the word guardianship, they don't really know what that means. So can you ladies start with just sort of describing what is guardianship? Like, what's the definition of guardianship?
Well, I'll go ahead and begin. And first, I want to start by letting you know the word guardianship. Let's go ahead and throw it out of our minds for 1 second and just focus on guardian advocacy. I know it's a term commonly used, guardianship, and mostly everyone mistakes it for guardian advocacy. But guardian advocacy is a legal process for parents, family members, caregivers, or even friends of adults with intellectual and developmental disabilities can obtain legal authority to act on behalf of that person to make decisions regarding their health, regarding their residence, for that person, and for their property.
So it's a really important distinction that we want to draw early on, that this phrase, this term guardianship, sounds really familiar to everyone. And that's because it's been part of the dialogue in all different jurisdictions for years and years. So the reason we're drawing this very specific distinction early on is because most parents that we at least speak to at the law clinic, which we'll tell you a little bit more about in a little bit, most of those parents want to be able to make certain decisions for their children when they turn 18. They're not looking to declare that their child is incapable of making any decisions for themselves and should have all of their legal rights stripped away, which is essentially full guardianship. So that term, full guardianship, it hits heavy when we hear it because the implications are quite extreme, and there are definitely circumstances where those extreme implications are required. However, typically when we're working with parents whose children have autism, have cerebral palsy, have one of the disabilities that we'll give you the list a little bit later of which ones qualify, they're not looking to declare that their child can do nothing for themselves. They just want to be able to make their educational decisions. They want to be let into the hospital room if there's an emergency. They want to be able to continue doing what they have been doing to help their child's entire life. It's a very interesting process because it really isn't changing what a parent does. It's just allowing them to continue doing what it is they want to do, and that's guardian advocacy. So that distinction we just want to make really pronounced right off the top because they are so often confused, and many have never even heard of guardian advocacy. They just assume guardianship, which is a much stricter process, and we'll get into more details about the distinctions, but just to start knowing that these are very different processes.
Well, I think we can kind of roll with that because I see that very often is that parents will call me and say, I want guardianship for a young adult who's their child, who the parents are thinking that they need to continue to make all these big decisions and little decisions for when the child may be a child that's on regular standards. And maybe college is in their future, maybe not. Maybe they're going to go to trade school, but they are making some of their decisions. The young adult is making some of their decisions, their own decisions, but the parent thinks that they're going to get guardianship. So I think now is a really good time to talk a little bit about that distinction between the guardian advocate and the guardianship, because I think actually most of the parents that I talk to are very unclear of what those two are and how they're different.
So we have a very helpful chart that I'm going to pull up. Talhia, if you want to start while I get that chart up on screen for everybody.
Sure. And just wanted to let parents know that it's very, very important to start laying the foundations for parents as their, child is turning 18. That way parents can become proactive regarding the whole legalese that comes into place regarding guardian advocacy or guardianship. So I think this is the best chart for us to explain the difference between guardian advocacy and guardianship. In guardian advocacy, it's only for adults that have a developmental or intellectual disability. Only those individuals can qualify for a guardian advocacy, whereas in guardianship, it is anyone that needs assistance. So anyone who has suffered an illness or an injury, someone can apply to become their guardian of that person. Now, in guardian advocacy, the chart states that no attorney is required. However, there is an exception, and that is when there is property involved, right? In guardianship, there is always an attorney required. So it's very important that regardless if you think your child qualifies for guardian advocacy or guardianship, seek legal help. Seek those who know this particular area of the law so they can give you the best legal advice possibly regarding your child, because no diagnosis is the same. In guardian advocacy, there is no examining committee, whereas guardianship there is, and it's a much, much lengthier process. There's no determination of incapacity. In guardianship, there is. That person who needs a guardian, who needs assistance in making decisions regarding their entire lifestyle is determined incapacitated. Personal rights are also removed in guardianship, whereas in guardian advocacy, no personal rights are addressed. And when I say personal rights, that means the right to vote, the right to get a driver's license, the right to marry. So those are specific rights that are not removed in a guardian advocacy case. And I think that's very important to illustrate to parents who are listening right now, because that is their main concern. When we meet with parents, they're very concerned whether, am I going to be taking my child's way of voting, of marrying in the foreseeable future if they want to vote, to have a driver's license. And it's important to make that distinction when they come to us, that in guardian advocacy, personal rights are not being addressed, right? We're not removing any of that. So I think that this is a great chart for parents to look at, to study, of the difference between guardian advocacy and guardianship. Guardian advocacy is a much lesser restrictive alternative, where we're not deeming their child incapacitated of making any decisions regarding their life.
I think the word that a lot of people hear, like I see the word in your chart, incapacity, and I think the word that most parents hear is competencies. And because sometimes I have to talk to them about, what's involved with that process, because it's not something that happens easily. Even if you do have an attorney and you enter into that process, correct me if I'm wrong, but there's a certain number of observations and interviews that have to take place in order to proclaim someone competent.
So I want to quickly start with just that language of incompetent and incapacity. And it really is, for purposes of, well, for all practical purposes, they serve the same. They're not that we need to get into the legislative history and the background of the statutes, but at one time the language was incompetence, and then it was switched to incapacity, and that's a side research issue, but that is what Talhia was describing when it came to the examining committee. That is that lengthy process that is involved with guardianship, where there are a committee of different types of professionals, psychologists, psychiatrists, all different professionals who have to make that determination. And then they are the ones that their words are given to the court to determine whether or not that person is incapacitated.
So this particular legal process pertains only to guardianship, and we'll get into guardian advocacy as well, because the legal process differs from one another. So in every case, whether it's for guardianship, guardian advocacy, and you need to file a petition, right? And that is the petitioner requesting to the court what they're seeking. So in guardianship, you file a petition, and then you have an adjudicatory hearing, and this is to adjudicate whether the person is incapacitated, and that is when someone has been judicially determined to lack the capacity to manage at least some of the property or some of the essential health and safety requirements of that person. And there is the guardianship. Between the adjudicatory hearing and the guardianship hearing, we have the examining committee that we previously mentioned, and that's where reports are introduced as evidence. And it's a 3-person committee, so they have all this evidence that attorneys are putting forth of the person with either a disability or an illness or an injury, whom guardianship is sought for. So between the adjudicatory hearing and the guardianship hearing, we have all of these committees making their observations, making their reports to determine whether this person needs a full guardianship. So until stage number 3, that's when they have the guardianship hearing. They're in front of the judge submitting all of the evidence. The examining committee will put forward their evidence as well. And after the guardianship hearing, that's where you have the court order, either determining the person that needs a full guardianship, or saying this person does not meet the burden of proof, no guardianship is needed. Now for guardian advocacy, the legal process, and we have a slide on that as well, differs a lot, in my opinion, because for guardian advocacy, you seek an attorney, you file your petition, and it says, among other pleadings. What are the other pleadings? IEPs. We need to have the IEP that reflects the diagnosis of the child. Because as we stated earlier, only those with a developmental or intellectual disability qualify for guardian advocacy. And again, just because you have been diagnosed with autism, cerebral palsy, does not necessarily and 100% qualify you for guardian advocacy, because every person is different, right? Every person can perform different tasks. It varies from one another. So it's the IEP that we need. Any type of evaluations from physical therapist, from occupational therapist, vocational therapist, those documents are extremely vital to our case when we have a guardian advocacy matter in front of us, because they serve as evidence. That's the evidence for showing the judge that this person qualifies for guardian advocacy. And does every adult require a guardian advocate? And the answer simply is no, right? A guardian advocate may be appointed if that person with a disability lacks decision making to do some, but not all of the decision making tasks necessary to care for his person or property. So whether you are able to make decisions regarding your healthcare, that is a big concern for parents, mainly regarding consenting to surgical procedures, dental procedures, anything regarding the healthcare. So once we file the petition, among the other documents, we within 3 days of filing that petition, an attorney by the court is appointed to the person with a disability. So not only the person applying to become the guardian advocate has an attorney, but the person with a disability has his or her own attorney. And that person is placed to ensure that the interests of the person with a disability are taken care of, right? They will have home visits, they will meet with their client, whom in this case is a person with a disability. They'll be able to observe how they live, how they react, how they communicate. They don't need to communicate verbally. They can communicate with with signs. And notice must be given to the person with a disability. Why? Because it's part of due process. If someone is trying to seek guardian advocacy of you, we need to provide you notice, right? And then once that notice is given, a hearing is held as soon as it is practicable. Now, since the global pandemic hit last year around March of 2020, many of our clients have been concerned, well, how long is the legal process now? How long do I have until I'm in front of a judge and I may or may not be appointed guardian advocate of my child? I need to know this now because I need to take my, my son or daughter to the doctor. I need to make decisions on their behalf, and I can make them right now because there is no legal document that allows me to do so. The courthouses are closed at this time, but thankfully we have technology, we have Zoom, and I think that our tribunal is making great decisions, and our hearings are being scheduled, at least for guardian advocacy in the Broward County area, are being scheduled within the few weeks. So parents don't have to wait around and, start worrying that they're not going to be in front of a judge within, few months or even a year. So a hearing is held as soon as it's practicable. And once that hearing occurs, at that moment, the judge may or may not appoint the parent or whomever is seeking guardian advocacy of the person.
So I have a quick question for the guardian advocate. They need to have an attorney or they don't need to have an attorney?
That is a great question. And the answer is it depends, which is our favorite answer as lawyers. And that is if they are applying to be guardian advocates of the person only, which would allow them to make decisions about medical care, education, their social environment, then no attorney is necessary. All the documents are on, at least for Broward County, all the documents are clearly on the 17th Judicial Circuit website. I know other counties have their own documents, but there's no requirement of an attorney unless there's property involved. Then an attorney is required.
Right. And I do want to point out that although no attorney is required if they're applying just to be guardian advocate of their child only, I do encourage parents to seek legal counsel for advice, because the forms may have language that, some parents may not understand. And the AIDD clinic is a great tool for parents to explore, at least in the Broward County area, because we provide pro bono services to parents, to low income families in the Broward area. And our main focus is guardian advocacy, right? So although no attorney is required, the AIDD Law Clinic at Nova provides pro bono legal services to parents, which means that they do not have to pay for our legal services to represent them, right? If if they qualify for our legal services.
And that's especially important, just that even though a lawyer isn't required, there is a lot of confusion. And as Talhia was talking about with some of the language, guardian advocacy, really the very first iteration of it came about in 1980, which really wasn't that long ago. And so it hasn't been fully developed the way full guardianship has been. And so it borrows a lot from guardianship as far as forms and language. And that creates a lot of confusion. We have clients who will look at a form and it'll be talking about things that we've never mentioned with them. And it's like, oh no, that doesn't apply to you. And of course we go through all of that, but if they're going on their own before coming to see us and they see these forms and asking these questions that really cause a lot of confusion, and it makes them much more nervous. It makes them think the process is going to be much more confusing and even expensive than they initially anticipated. So that's just something that we'll keep in mind for all parents listening, is that knowing that those forms oftentimes are shared, and that is why there may be some language there that doesn't apply to them.
Yeah, for parents, it's like it takes them a while to learn about IEPs and everything that they need to know about their rights to education. And then, then they have to try to figure out the vocational rehabilitation system and jobs and job supports. And so this is just another really, in most parents' minds, another enormous obstacle really for some of them, because for people like you ladies, this is what you do. So we always encourage parents to reach out to organizations such as yours to gain that information, because it's just another complex system that parents have to really be able to wrap their brains around a little bit so that they can start making those good decisions for their children. What age do you think families should start thinking about this whole issue, guardianship, guardian advocacy?
Usually, I believe the typical, this is just from our experience with Broward County, what we hear is that they typically start having their transition meetings in public schools around age 14. And I think that's a great time to start thinking about it. Legally, there is nothing that we can do. The court cannot appoint a parent a guardian advocate until the child is 18, because that's the legal age. But the process can start 6 months before then, as far as the actual process of us going through and filing and such. But even as early as 14, which we definitely encourage, parents can start putting together packets of documents. These, as Talhia said, what we put forth as evidence is the IEPs, maybe a doctor's report. But these are documents that oftentimes I have parents who will come. I had a client speak to me whose child is 47 and doesn't know where any of these documents are. So just knowing where all of that is and keeping it together is a really good first step that they could start taking as early as now, however old the child is.
Right. That's why I mentioned earlier that it's very important to start laying the foundation and be proactive regarding, the whole guardian advocacy process, because the earlier you apply for guardian advocacy, chances are that you will have an IEP available. Compared to, as Leigh said, if your child is in the 30s or 40s, you may not have those documents readily accessible for you to provide to the attorney. And as we said, when we apply for guardian advocacy, we don't get a hearing the next day or in 3 days. Sometimes it takes times. It depends on the judge's docket. So there are some times that we may have to wait to get a hearing in front of a judge. And it's very important to have those documents available, because that's the evidence that we put forth for guardian advocacy.
We talked a lot about how guardianship is this much more extensive process and all those things with examining committees and such. The equivalent in guardian advocacy are those pieces of evidence that Talhia is mentioning, those IEPs, those doctor's notes. It's a lot less involved in guardianship, but there makes them all the more necessary, because those are what is doing the work for guardian advocacy proceedings.
Yeah, for you guys who are parents, just like I always encourage parents to do, is have, like, even for your IEPs, have a binder and keep everything, keep your psyche evals in there, your IEPs, your reevaluation plans. And when you keep everything together, if you get to a point where you need to exercise your educational rights, it's always easiest when you have all your data. And this is just another example of why that is a benefit, to keep your binder, to keep all the stuff in one binder. That way, when you're at this process, you've got everything already together. So it's not going to just benefit you with advocating in your school, but it's going to benefit you as you move into this sector too, which could be a little, complicated. Really don't understand what is entailed. Ladies, you had more in your presentation that you wanted to share?
Yeah.
Yes.
Okay.
So
I'll let you get back to your order. I kind of bumped you around. I'm sorry.
No, this is good.
No apologies necessary.
Definitely. Well, we'll speak at just a second about the clinic itself, just so anyone who is in the Broward County area knows that we are here and that we have this service. We talked about it a bit, but I just want to bring it back just to make sure. The Nova Southeastern University Shepherd Broad College of Law Adults with Intellectual and Developmental Disabilities Law Clinic, which that is, you contact us if you are interested in our services. We, as I said, it's pro bono for qualifying clients. And if you don't qualify because maybe your income is higher than we're able to help, we can refer you to people. We have a lot of contacts in the community, but we work with those in Broward County, although we have contacts in Dade County as well. And we're a good place to start, even if we in the end are not the ones doing your case. We have information, and our goal is to spread that information far and wide.
Right. And I wanted to emphasize also as parents that even if, the information we're sharing today applies to you or overwhelms you and you have follow-up questions, contact the clinic. Leigh and I are available to speak to parents, even if you're not in the Broward County area. I know that it's a big concern for parents that, oh, if I contact a lawyer, they may charge me a consultation fee and I don't have, the necessary means to pay for a consultation fee. Contact us and, we'll give you guidance. And, like Leigh said, even if we're not the attorneys who are going to represent you in this matter, at least we can give you some type of, sense of peace regarding the whole guardian advocacy process.
So we talked about, so we're focused today, of course, on autism, but just for your knowledge, guardian advocacy is available for a set number of disabilities. So we have intellectual disabilities as well as the developmental ones that qualify are listed here. So we have cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, and Prader-Willi syndrome. And these are statutorily determined, which is just a fancy way of saying the law for guardian advocacy says that these are the only qualifying diagnoses. So that's also an important thing, that when you have those IEPs and those doctors' notes, that they are very specific when they are writing these things down, that it says autism, because if they don't have the specific disability written down, the court can give a lot of difficulty because they want to make sure that everything is aligned with what the specific language is. So it's just another point to remember, that when you're compiling these IEPs, that they all have the correct things written on them, because that will matter. And it's also important to be doing this early because you need evidence of the diagnosis manifesting before your child turns 18. So if you wait until after they're 18, I know we've gotten IEPs from parents of their child last year in high school, but they're already 18, and that IEP is useless for the court for us. We need it to be before, the court requires that it be before 18, that evidence of the diagnosis. So we spoke about this already, that it really is, everything is so situation dependent. There's not a one size fits all with these. When you're getting to that topic of transition from child to adult, everyone is going to have different needs, and it's just really important to be aware there are options for varying needs. I think this is important. We touched on this, but just so we have it laid out in front of you, these are the specific rights that you as a parent can petition the court for when you to become a guardian advocate. You are petitioning the court, you're asking the court for the right to determine your child's residence, to be their representative payee for government benefits, to be able to make healthcare decisions, to be able to make decisions about their social environment and their educational needs. And that doesn't mean that you need to request all of these, but these are the 5 categories of rights that you can petition the court for. And then, as Talhia already mentioned, there are certain rights, those personal ones, that the court is not going to take away and give to a guardian advocate. And as we've already mentioned, and we're just emphasizing, clients, what come to us, their biggest concern is that one day maybe their child will get married, and they don't want to do anything that's going to jeopardize that. And guardian advocacy won't jeopardize that.
Yeah. So who can apply to become a guardian advocate? And that's the question that we often get with our clients. And first, it has to be a resident of the state of Florida who is at least 18 years old, of sound mind, or a relative by blood or adoption, right? Usually, at least in our cases at the clinic, it's mom and dad. It's mom and a sibling, or it's a sibling. And many of our clients want to apply either with another child to become co-guardian advocates. So I want to point out that you can also have two guardian advocates in one scenario, and the decisions are split 50-50, right? So both co-guardian advocates must be able to make decisions regarding the adult with the disability, and they need to act in the best interest of that adult with a disability. So it's very important when we have co-guardian advocates that they're able to make decisions in the best interest of the person, and not just always be on the fence regarding healthcare decisions, residence, social environment. And if I know that I know there's another slide regarding the frequently asked question. If I'm not able to become, the guardian advocate of my child, then who can? I think that's case by case basis. So when a client contacts us and for whatever reason they are not eligible to become the guardian advocate of their child, whether it may be there's a felony conviction, there's a misdemeanor in their record, they have been, judicially determined that they committed abuse, abandonment, or neglect, which in Florida is, there's a dependency case, or if it's a doctor, they provide substantial services to the person with a disability in a professional capacity. So these are disqualifications that perhaps someone will not be able to become a guardian advocate, but that is when I encourage you contact an attorney, because there will be a list of questions that we will ask you to be able to come to a decision on who can apply to become a guardian advocate of your child.
Talk about the legal process. Talhia, do you want to go through the responsibilities?
So what are the responsibilities of a guardian advocate? First and foremost, to act in the best interest of the person with a disability, right? One of the documents that we file for that guardian advocate is an oath. And that oath is signed in the presence of a notary, and you are saying that you are going to faithfully carry out your duties as a guardian advocate. Guardian advocate is a privilege, right? And we should make the best decisions as possible for the person with a developmental disability, even if it is our child. Another responsibility is to file an initial guardianship plan. And I know it's a little bit controversial that I'm saying initial guardianship plan for guardian advocacy. And that's because, as Leigh mentioned early on, there's very little law regarding guardian advocacy. And many of the legal process for guardian advocacy, it borrows from the statute of guardianship. So some of the documents will be used for guardian advocacy and guardianship as well. And this is where we guide our clients as to what questions apply to them, what should be filled out. But they file an initial plan, and that initial plan asks questions such as, can the person with the disability bathe themselves? Are they able to cook a meal for themselves? Are they able to drive? What are some of the daily life activities that they're able to perform and what they're not able to perform? Which brings me to my second point, which is file an annual plan every year. Every year that someone is appointed to be a guardian advocate, they must file an annual plan. The annual plan is identical as the initial plan, and that is the same questions, but the guardian advocate is just updating the court as to some of the tasks that the person with the disability is able to do and not do. And the reason why they do that every year is because through therapy, through physical therapy, occupational therapy, perhaps some of those tasks of the person who were not able to perform in the past, they're able to do so now, right? So some rights may be restored depending on the annual plan. They must submit to a criminal background screening. So that's one of the out-of-pocket expense that a proposed guardian advocate must do before they file to become a guardian advocate. And they need to complete a guardianship course. The guardianship course varies depending on the county that you're filing. In Broward County, you have the option of completing it live in the Broward County Bar Association, or you can also do it online, guardianship.com. I know other counties, you may be able to do it through a local church. So it just depends where you are filing for guardian advocacy.
And just to bring back the out-of-pocket costs that Talhia mentioned, and here in Broward County, that can be the courses that most of our clients take is the online one. COVID, it's really their only option the past year. That is about $129. And so just to keep in mind that there are expenses, and I mean, they're less than what the filing fees are with the court, which if you qualify for the clinic services, we handle the court fees. So just to keep in mind that if someone does qualify for our free legal services, there still are those out-of-pocket costs for the criminal background screening, which I believe in Broward County is about $70, and then the guardianship course, which is at about $130. So just to keep those things in mind. And then if you don't qualify for our services, then there are private attorneys, some that work on a sliding scale when it comes to the actual legal fees. So those are just all things to keep in mind, that yes, guardian advocacy is a much less expensive process than guardianship, but there are still things out there, and there's ways to work with whatever situation you're in. So just keep those in mind. And once again, we're happy to talk to you about, getting in touch with someone who can maybe help you for a smaller cost, etc. Then I think we covered most of the frequently asked questions.
Well, let me just look before we go on, because we did have a few questions from our Facebook group that's watching. So let me just see. Somebody said we have to wait for 18 to, do we have to wait till 18 to file, or can it be done prior, a few days or weeks before age 18?
You can file at, I believe, age 17 and a half, so that's 6 months, but the court is not going to appoint until 18.
Another question is, if we were granted guardianship of our adult daughter through the court system in a different state, is that guardianship still valid in Florida?
Are we talking about full guardianship? It must be, because not all states have guardian advocacy. So they probably are referring to full guardianship.
She just says guardianship. So I'm going to assume that it's full guardianship.
My understanding, once again, our specialty is guardian advocacy. My understanding is that the state that they move into needs to accept that guardianship, but I don't think it's a difficult process. Talhia, do you know anything more about it?
I don't know the exact process, but I'm sure that if there's full guardianship, there is an order, and we might be able to domesticate that order here in Florida so it can also be applicable. But again, we would have to take a look at that order and see what it states, because keep in mind that every state has its own law. So the law of guardianship in that state where they obtained it might differ here in Florida. So
Yeah, here's a question. If guardian advocacy is granted, but into young adulthood, the person needs full guardianship, can that be changed?
so is the question, they obtained guardian advocacy first?
Yes. And
And
now I
then
guess the needs are showing that maybe there are bigger needs. And so if a full guardianship is something that they want to pursue later, can they switch from the guardian advocate to the full guardianship?
with the proper evidence. So it's a very particular process, because when you are appointed, when the guardian advocate is appointed, the court is making an order that the individual with the disability can do some, but not all of their activities of daily living. So the court has made a judicial determination that they can do some. And so because of that, will be a little bit more difficult to then come back to the court. You'll need new evidence to show that they no longer can do some. We have not had personal experience with that process, but that is something to keep in mind, that there is a court order being put in place when a guardian advocate is appointed that specifically says that that individual with the disability can do some things. And there is, in Florida, there is a part of the law that says that you need to go with the least restrictive means that is still going to provide safety and provide for the needs of the individual. So if there's this order from the court saying that guardian advocacy was appropriate, you'll have to show that something has changed.
Okay.
Right. So just to quickly emphasize on Leigh's answer, that we do need to bring forth new evidence showing that some tasks that they were able to perform in the past can no longer do. Perhaps it might be due to an injury. So if injury occurred to that person with a developmental disability that now prohibits him or her to do any tasks about, for hers or his person, then perhaps full guardianship may be the alternative. But if there are no new evidence showing that those tasks can no longer be performed, then the court may not authorize that guardianship.
Yeah, I have a feeling why parents would mostly be thinking this way with the switchover is because when, let's say that they get it, right when their child turns 18 and they get the guardian advocacy, they're living at home, parents are still taking care of them, they're not working, they're still in school. And then all of a sudden they're 25, they are out there in the world and not necessarily as protected as they were, when they turned 18. So I think of the parental perspective now is changing. Maybe not so much the individual, but their perspective where, oh, they're in my house, I'm taking care of them. We go to bed at 11 at night, we get up at 7 in the morning, and the parent is still kind of taking care. Where then when they see they have a 25 or a 30-year-old who's out in the world and has a job, and I think it's the fear of the world, because now the world is going to greater impact them because they're not nestled in a school or into some type of protective program, but rather they're out there and they're working. And I don't know. In some situations, I would think it's not the individual that has changed, but I think the parental perspective on building around the securities of that person has changed a little bit.
It sounds like, in just some conversations we've had with other colleagues in this field, that there is that distinction between just a normal parent's concern for their child and wanting to be able to exercise what they believe is the best thing for the child, rather than what there actually is an inability there. And I'm not a parent, so I can't speak to that but that is something that is definitely, I think, important to think about is when we're making these decisions, when a parent is deciding what they want to apply for, thinking about it in terms of what is it that their child can and cannot do that can be shown evidentially.
Another question, if the child cannot make their own decisions now, what harm would it be to have full guardianship? My daughter has Down syndrome and a very low IQ.
So it's possible that the court won't grant guardianship. If the court does not think the evidence is sufficient to show that full guardianship is appropriate, they won't grant it, and guardian advocacy could be the only option. So it's not just about, there is a choice as far as which avenue to pursue, but once you choose an avenue to pursue, you still need the sufficient amount of evidence to convince the court of it.
Right. And, some of the questions that we ask our clients whose children have Down syndrome or spina bifida or cerebral palsy is, what are the verbal skills of your child? Language skills, mathematical skills. Are they able to prepare a meal for themselves? Are they able to, wake up, be able to put their, their shoes on, decide what clothes they want to wear, they decide what they want to eat. And these are questions that a judge will also ask the parent, and that's the difference between guardian advocacy and guardianship. Someone who needs assistance in guardianship cannot make any decisions about their daily lives, activities whatsoever. But in guardian advocacy, you can.
Yeah, and I mean, I've heard of cases where there is full guardianship granted, and then later on that adult takes it to court because they want
Right.
to have some of those rights. They want to be able to go vote. They just want some of their own rights. So I've seen those actually, people go to take their own parents to court looking to get those rights back.
Both guardianship and guardian advocacy are court processes. It's not like powers of attorney, healthcare surrogates, estate planning documents, and things like that, which you don't need a court order for those things to go into place. With guardian advocacy and guardianship, the court is now involved, and that has different implications when it comes to what the parent wants to go ahead and do with the child if they have full guardianship.
Can you, you just mentioned power of attorney. So can you just touch on that for a really brief minute, even if you just give a definition of it? Because I think some parents of kids who are graduating on regular standards, who may be headed towards college, our office gets some questions about those, like, should I get a power of attorney? Because yes, they're going to go to college, but yet they still have these needs and need to protect them a little bit.
Right. I think and I know Leigh will piggyback on my comments, but for power of attorneys or any estate planning documents, the person with a disability must be able to consent, right? So it's a document, it's not court order, so it does not have the approval of a judge. You don't need to go through the court system to obtain an advance directive or healthcare surrogate or powers of attorneys. It's between, in this case, the parent who wants to be able to decide, for medical purposes or financial purposes for their child. And the child, who in this case may have a developmental or intellectual disability, that child must be able to consent in order to sign that power of attorney. And it's just basically giving the parents the authority to make decisions on their behalf regarding whatever purpose is stating on that legal document.
Thank you, ladies, so much for such invaluable information. That was really fabulous. And I'm sure that there's going to be so many parents who benefit by what you offered today. So thank you so much. For the rest of you guys out there, thank you for joining us for another episode of Reach. In a week, we're going to be hearing from Dr. Geraldine Dawson, who is basically world known for early intervention. So you don't want to miss that, especially you guys with the little kids. It's going to be really great info. And then after a couple weeks after that, we're going to be hearing from an author who's going to talk to us about resiliency and how to build resiliency in people with autism, whether it's for yourself or whether you are a parent of a child with autism who's kind of looking for some tips on how to help your kid develop those skills. So thank you once again for joining us. We hope that this was a really good bit of information for you to guide you along your journey, and we will see you next time. Thanks so much. Bye-bye.